Good morning. May it please the court, I'm Robert Lincoln. I'm appearing today on behalf of appellants Thomas Petersen and Inge Spatuzzi. I'd like to reserve 8 minutes for rebuttal.
Mr. Lincoln, we generally will go up to about 5 minutes on rebuttal. So why don't I reserve for you 5, and if it ends up that you need a little more, we'll deal with it then.
Thank you, Your Honor. Alfred Lord Tennyson once wrote, "A lie which is a half-truth is ever the blackest of lies." The case before the court today involves a half-truth on a ballot language that was put before the city of voters of the City of Clearwater with respect to an amendment that was adopted. And the half-truth issue is important because it frames what the trial court missed and what this court has to address. The ballot language that was put in front of the voters was truthful and accurate in some respects. It correctly identified the type of lease that was being contemplated between the City of Clearwater and the Clearwater Marine Aquarium, and it correctly identified the property that would be affected by that lease.
You have to concede that to the extent the test is, does it reflect a chief purpose? Chief purpose was disclosed to negotiate a lease for the aquarium downtown.
The chief purpose, we believe, was not disclosed. We believe that to find the chief purpose, the cases tell us you look to the amendment itself, the legal effect of the amendment. The chief purpose of this amendment is reflected in the very first line of the amendment itself, where it says, "Notwithstanding, and as an exception to anything contained in sections 2.01 D5, D6, and D7 herein, the City Council is authorized to negotiate the lease that was described."
So are you arguing that if the voters had disapproved of this, voted noes, and the noes prevailed, that the city would not be able to that the city would still be able to negotiate this?
The city would have been able to go through the processes and negotiate a lease that was consistent with the provisions of the city charter, but it's not the critical issue. This gets into the different ways that a ballot summary can violate the statute and the Constitution by not stating the chief purpose or being misleading about the chief purpose. The test, in fact, it identifies both of those as separate issues, though they tend to be related. And the issue here is that the whereas clauses of the ordinance itself identifies the different provisions of the charter that they would have had to comply with if they wanted to go through this and enter this lease without amending the charter.
But isn't the purpose just to highlight the basic purpose of the vote, and a voter who is inquisitive could go and look at what these other sections are?
The statute requires that the amendment language, the ballot language itself, fairly inform the voters of the full import of their vote. And the cases have been very clear.
Actually, the statute says the chief purpose of the amendment, not the full import of their vote. It just says the chief purpose.
That's what this...
I mean, anyone reading this would know that the chief purpose of this ballot is to vote whether the city can lease this land to build and operate an aquarium for 60 years. What else is in here that's misleading?
It's what isn't there. This is a what is not said case. This is a case that turns on what it did not say. It did not say that they were going to be exempt from protections for this property and protections against this kind of deal that the voters had put in the charter already. It doesn't disclose to the voters that, for example, there will be no recapture provision as required by the charter, that the property will not be required to be declared surplus before it could be leased for these purposes. And it doesn't put the voters on fair notice that they could or should go look for those kinds of issues within the charter and with respect to this deal. And this is exactly the kind of thing that the courts have been concerned about in the various cases. This is a hide the ball kind of case. This is like the case where the amendment is in front of the voters, asking them to approve changes to the constitutional provisions that had been adopted that prohibited legislatures from lobbying for 2 years. And they truthfully said that this amendment will require disclosure. Legislators who lobby to disclose the fact that they're lobbying, but didn't say that they're taking away the absolute prohibition on lobbying. And the Supreme Court said that's a form of hiding the ball. It's misleading the voters when you are, in that case, just flipping over, changing a prohibition to a disclosure requirement. Here, it's, again, a truthful statement about one aspect of the effect of approving the voter of the amendment, but not telling them the other critical aspects that it is exempting.
You're not going to get that in 75 words. What you want is not going to be done in 75 words.
It absolutely could be done in 75 words if they're going to do it legally and put it in front of the voters. But and it's the city's responsibility to come up with language that does that. And we've never stated that they had to disclose somehow the full effect of every one of the provisions for which an exemption would be created.
But if the ballot question provides for negotiating a lease by adding section 2.01D8, a reasonably inquisitive voter would be put on notice that there are other provisions that may be relevant to this, and they can go and look it up and see how this new 201D8 is going to interact with the other provisions. And that the chief purpose has been given to negotiate a lease in the context of this new section 2.01. That's what I'm struggling with.
And the problem really is that what do you take from the words in the ballot language, shall the city be allowed to? They're saying that this is going to change the question is whether the city should be allowed to. And maybe it does raise the question, well, why aren't they allowed today? And the question then becomes, if there's reasons why they wouldn't be allowed today, doesn't somebody have to be pointed towards that? The courts have continually said yes, that when you know, and in fact here it would have been easy to disclose. If they had put, and again, it's not on our burden to demonstrate what the valid language would have been, but if they had just said that should sections D 201.D5, 6, and 7 be accepted, so that the city commission do it, they could have put a small phrase in there.
Does that make it more confusing?
No, I actually think that would have been, the city has argued that, but I don't see why. If the issue is that the first line of the actual amendment states that there's going to be, this lease is going to be exempt from these other provisions, I don't know why it would be confusing to tell the voters that the amendment is going to have the effect of exempting this lease from those specific provisions. And again, this is the problem with a ballot language that has a half-truth, that has an omission. And there is a balance. There is a point at which you have to say, you know, what aspects have to be included, what aspects don't have to be disclosed. And the courts, in looking at these cases, have made distinctions. And in the secondhand smoke case, some of the other cases cited by the city, the courts have said, you know what, if you're changing the Constitution and the objection is this will have effects on statutes or policies or other lower forms of law, those kinds of effects don't have to be disclosed. But when there's going to be impacts or effects relative to this proposition with the Constitution, you have to have some way of disclosing it. And the ballot language is misleading if it doesn't. The city charter is the Constitution for the city. It's the equivalent document on the city level of the state constitution at the state level. And we're not talking about a exemption from policies that the city commission had adopted or even ordinances.
But the ordinance as adopted will provide that notwithstanding these other sections, we're going to try to negotiate a 60-year lease, correct?
And that language was put into the charter by this amendment.
That was in the charter. And I'm still struggling with trying to understand why the voters in the summary would have had to been told that.
Because
Having been told that there's going to be a new section that's going to allow for this negotiation of a 60-year lease.
Because by approving this, they were giving up rights and protections that the voters had put into the charter, and not just generically into the charter over some things, but specifically to control these kinds of deals. Those are the sections that were in subsection D5, and specifically with respect to this property in D6 and D7. The voters had said, we want protection against these kind of deals. We want to limit them.
Why isn't it implicit in the ballot summary that the rules are going to be different for this particular deal, this particular transaction?
The problem is that it's so implicit that it is omitted. And that is exactly the judgment call. The problem here, that by leaving it implicit, by not explicitly saying we are creating exceptions to allow this deal to go forward, and then putting somebody on fair notice to go look up what those were and whether the voter thought they were important enough, they could leave the voter thinking that all of those other restrictions would still apply. An informed voter reading this ballot summary, who knew the charter and knew that those other provisions were in the charter, might not realize from reading the ballot summary language that the actual amendment put that explicit exception language in there.
Isn't that the purpose? I give some modicum of notice to the reasonably informed voter, and if then that person wants to get more information, they can do that.
And this is the problem. That modicum of notice, when the change involves doing something like that undoes an existing protection or alters it significantly, that's when it needs to be called out. That when you need to give some additional information to the voters to indicate that they're making that kind of change. And that's been consistent through the cases mostly that involve the state constitution across the lines, and it's the key distinction when you read those cases. Cases like the NAACP case on the treating people differently, where the election, the change would have implicated other existing constitutional protections for equal rights and equal protection without saying so. In the case that involved the first redistricting attempt to change the redistricting standards, where it would have affected the contiguity requirement, and that wasn't disclosed. And the issue wasn't specifically, if it's going to affect the contiguity requirement, that specific issue has to be identified. It's, we're changing the rights. I mean, again, reading between the lines in that particular case, if the ballot summary had said, notwithstanding other provisions in the Constitution that deal with redistricting, these are the new standards that are going to apply, but it didn't say that. So it didn't give the voters fair notice to even go look and think about the other kinds of things that were involved, and it changed those rights. And that's the key distinction, is that at a certain point where you're changing core rights in the core document, the core governance document, the state constitution in the case of the state, or the charter in the case of the county with a charter or a municipality, the disclosure requirement is heightened because it affects existing established rights that the voters and the people have put into place. And that heightened requirement doesn't...
Mr. Lincoln, you've used
Okay.
15 minutes. I just wanted
Okay.
to let you know.
When we look at the cases, that heightened requirement isn't a full disclosure. But it is a disclosure that would put people on notice of the nature of the change. And this is the distinction. We can argue the chief purpose. I believe that when you read the amendment itself, particularly in the context of the rest of the ordinance, it's clear that the chief purpose of this was to create the exemptions so that they could do the deal that they wanted, not to just be able to do the deal. I'll leave it at that.
May it please the court, my name is Alan Zimmett. With me today is Nicole Nate. We're with Bryant Miller Olive. Together we represent the appellee, the City of Clearwater, in this matter. And Judge LaRose, you hit the nail on the head. This case, really, the core of this case is what is the chief purpose of the charter amendment that was proposed by the City Council of the City of Clearwater. And when looking at the case law, how you determine the charter, the chief purpose, you look at the amendment text, you look at an objective standard. You don't look at what voters may have thought. You look at an objective standard. You look at the text of the amendment. In this case, looking at the text of the amendment, clearly the chief purpose was to authorize the City Council to negotiate a lease with the aquarium for the construction and operation of aquarium on certain city property for a term of 60 years.
But the existing ordinance, seems to me, reflects some real concerns by the citizens of Clearwater about, what I'll say, the sanctity of certain parcels of property and how they were going to be treated.
Yes, the charter contains protections for certain properties in downtown Clearwater, and the voters have been presented previously similar questions as this question was presented, and both have approved and denied those other exceptions that were proposed similar to this one with similar ballot language, and that is part of the record. So yes, the voters are familiar with these restrictions, and in fact they were, the ballot language in this case referenced the voters to the ordinance, which gave a recitation of the provisions, really summarized them, that would have given the voters, if they chose to educate themselves, notice, probably better notice than for the average voter to go read the charter provisions as to what these charter provisions provide and what the exception was seeking an exception to, what they were seeking an exception to. But
let me get your sense on this, if I'm hearing Mr. Lincoln right. The summary tells us that we're going to have negotiations for the aquarium downtown for a 60-year term. The existing charter, very simply, would preclude a 60-year lease, correct?
the existing charter would have precluded this lease for a number of reasons, that being one of them.
I guess if I hear Mr. Lincoln correctly, the voters should have been told that this 60-year term is really a big change from what's in the charter.
And for a number of reasons, and there's numerous courts that have looked at issues similar to this and determined that that is not misleading. Given the 75-word limitation, we have a 73-word question here. The 75-word limitation, you can't possibly address every single ramification. The courts have favorably looked at when a ballot question gives voters notice of somewhere else they could go to find and educate themselves, and in this case, there's a reference to the ordinance where they could find all of that information. There's 29 whereas clauses in that ordinance. It concludes with the chief purpose, which was that the council found it was in the public's interest to lease the property to the Clearwater Marine Aquarium for the 60-year term for the construction of the aquarium. But for example, if you look at Florida Education Association case, if you look at Harris versus Moore, Mr. Lincoln states that all these cases, when they look at constitution and charter changes, I think he actually said in his brief, they all conclude that when there's an omission with regard to anything that's the existing rights or provisions that are in a charter or in the Constitution, that automatically makes it misleading if it's omitted. Look at Harris versus Moore. In that case, a 4th DCA case, in that case, the trial court found that the ballot question was misleading. and cited many of the same cases that are relied upon by the appellates in this case. The fourth DCA reversed. The claimed omission there was that they were changing the form of government of the county from a commission manager form of government to a strong mayor elected form of government. And the fourth DCA said in that case that that omission was not misleading. It was not affirmatively misleading, and they held up the ballot question. In the Florida Education Association case, a case that involved an amendment to the class size, Supreme Court indicated that the ballot question in that case was not affirmatively misleading because it didn't provide a false impression as to the funding obligations that the legislature, that had been posed on the legislature for the class size amendment that existed, and therefore the omission of the reference to the existing and the effect on the existing class size provision in the Constitution was not misleading. And there's other cases that have similar results as those two. Those two, I think, are most on point with our case here, where many of the same arguments that were made there, many of the same cases. When you look at the appellant's cases that he cites as the issue that the Clearwater ballot question was misleading, many of those cases, they fall into three basic categories. One, where they gave false impression as to the meaning of the vote. They were inaccurate. So, for example, you look at the Armstrong case, where they were changing an existing rule, the cruel or unusual punishment rule in Florida, to the federal rule, cruel and unusual punishment. And yet they misled the voters with regard to the fact that there was an existing rule that said cruel or unusual punishment. They implied by that ballot question that they were creating for the first time essentially this new rule. Other cases that he cites, casino authorization, these are cases where the voter was not going to get what they voted for. In this case, the voters are going to get exactly what they approved on November 5th of 2014. They're going to get the negotiation of a lease by the City Council with the Clearwater Marine Aquarium.
One significant change that was mentioned but really wasn't focused on is the elimination of the recapture and reverter clause. That seems to me to be a fairly significant change in the rights of the people to property and getting their property back. I'm concerned that wasn't addressed at all.
Well, again, the standard is that you're not required to address every ramification. 75-word limit. I think it was important, as Judge LaRose indicated, to advise the people of the City of Clearwater of the location of the property that they're talking about, because the citizens had taken interest.
The ballot language advises of the location and advises of the term of the lease. It does seem to address what I think everyone is talking about, which is what's the chief purpose. But the change or the limitation on the recapture period also seems to me to be quite significant. So is it your contention that the reference to the ordinance and the charter is sufficient to put the public on notice that the law is changing, the Constitution of our city is changing, and if you want to find out every detail of it, you need to go read the Constitution again?
Absolutely, and that's what the courts have said. I mean, it's impossible to judge in a 75-word ballot question to hit every ramification, especially when you look, the text amendment itself was 335 words. That doesn't even address how many words were in 2.01 D5, 6, and 7, which we're talking about. To try to address every single one and pick out which ones would be virtually impossible. If you look at the ordinance, which the voters were referred to, there's 29 whereas clauses. The council went through all of these provisions so that if an informed voter wanted to educate themselves, they had the opportunity to look at the ordinance and read what those provisions were and have a summary of them as opposed to trying to comb through the city charter themselves. And again, the chief purpose, as stated in the final whereas clauses, was to lease the property, which is the obligation of the city in putting the voters on fair notice of the chief purpose. They need to address that chief purpose in the 75 words that they're allotted. In the court below, the appellants admitted that the ballot question was accurate, and that as a result of the approval of the ballot, the voters are going to and have authorized the negotiation of a lease with the aquarium. And when you look after case, That's what the courts have basically come down to. Are the voters going to get what they voted for? The other cases that the appellants rely upon, NAACP branches, for example, that he mentioned today, there was no ballot summary provided at all. They included the entire text of the amendment in the ballot question. And so that got struck because there was no discussion, no pointing to the voters, what is the chief purpose? The court, didn't want the voters to have to comb through the amendment text to determine themselves what the chief purpose was. The third set of cases is where the ballot question uses terms that are different than are used in the text, that have very legal terms that affect the chief purpose, and they use terms in the ballot question that are different than the amendment text. And so clearly they were misleading because they are using terms that don't comport with the actual text of the amendment. Clearwater's question did not give any false impression about the present charter provisions. In fact, the present charter provisions, yes, they created an exception, as has been done before to these provisions in a similar ballot question. They created an exception, but the actual provisions themselves are not being changed. They will continue to, and today, continue to be in effect with regard to the other properties in downtown Clearwater. And downtown, the properties that are described in those charter provisions is much broader than the properties that are being addressed or in this specific ballot question and that would be subject to the potential lease with the aquarium. So those, many of the cases, again, that find questions misleading are where they're changing the specific constitutional provision and it will be different going forward. So the cruel or unusual punishment rule becomes the cruel and unusual punishment rule, but you don't tell the voters, hey, we have an existing provision. You ban lobbying, okay, but you imply to the voters that if you vote yes, that'll mean one thing when it actually means something different. And if you look at the cases, the casino authorization case, similar thing. They give a false impression as to what the result of the vote would be. In this case, it's clear that the result of the vote, that the voters will get exactly what the ballot question says, is they're going to get the authorization to negotiate a lease with the Clearwater Marine Aquarium. The appellants argue so much about the notwithstanding clause, because the clause, notwithstanding, means to spite of. So in spite of these these provisions, should we create an exception to do the aquarium lease? I would submit that an objective reading of that language would result in only one conclusion, and that is that the chief purpose was to authorize the lease to the Clearwater Marine Aquarium. They also mistake the need for the referendum with the chief purpose. The courts don't say you have to explain to the voters why we need a referendum. In fact, there's a number of cases where the courts have said we're willing to assume the voters understand why we're asking you for approval. And so they mistake that need for what the chief purpose is. The chief purpose, again, being that the city council was requesting the voters to ask them if they wanted to authorize the council to negotiate the lease. The courts apply various standards in review of these cases. They give great deference to the legislative bodies, to the voters, and the election process. Therefore, they have established difficult burdens of proof on those challenging ballot questions and demanding rules of law reflecting strong policy towards allowing the voters to decide. The voters here decided on November 5th to approve this amendment. The courts act with extreme restraint before removing a ballot question from the voters. Thus, the burden of proof on the appellants in this case is to prove that the ballot question is clearly and convincingly defective. And I'd submit that they have not met that burden. Courts don't rewrite ballot questions. They don't consider the merits of ballot questions. The appellant has suggested that we refer to 2.10 D5, 6, and 7. What more would that have provided the voters? That would not have provided the voters with any notice as to what was in those sections. Again, the ballot question referred them to the ordinance where they could have found that information. And the courts assume that voters have a certain amount of common understanding and knowledge, and they have a duty to educate themselves. The courts repeatedly have said that given the 75-word limitation, perfection is not required, and all ramifications do not need and cannot be addressed with that word limitation. As I said before, the proposed amendment did not change the rights or the provisions of the 2.01 D5, 6, and 7. The ballot question was not required to explain their complete terms at length. The ballot question gave the voter fair notice of the main effect of the amendment, as I said a number of times this morning. Adding language proposed by the appellants would not have better informed the voters. In fact, we think it would have hampered their understanding of the main effect, which was to lease the property to the aquarium. The voters will get exactly that. And the lower court properly found that in clear and unambiguous language, the voters were provided with fair notice of the decision they were to make, and the voters made that decision in November. We believe that the appellants have not met their burden of proof to show that the ballot question was clearly and convincingly defective. We would ask you to affirm the summary judgment granted to the city and give the deference that the courts have for many, many years given to voters, give to the voters of Clearwater and the election process that took place on November 5th. Thank you.
Thank you, Mr. Simon. Mr. Lincoln?
Let me first address the Harris v. Moore case, because I think it actually is instructive. In Harris v. Moore, the issue is that they were changing from at-large to single-member districts and having an elected mayor. And the complaint that was raised against it was that other ramifications of making that change weren't disclosed. Not the actual change on the charter, but that, people would lose their ability to have an at-large representative, things that were obvious, and that would dilute or change the voters' effectiveness, or that the fact that there would be a single mayor would have an impact, other impacts in terms of people's rights that they enjoyed, but there were secondary effects. They weren't the direct effects of the amendment themselves on the charter itself. It was the secondary political fallout that would have occurred from making those changes. And the court did reject, and I think properly rejected, that as making it incomplete or misleading. The other cases that involved these big changes is, yes, in the Lee County case, they were adopting the county charter for the first time. Being told that they're adopting the county charter for the first time and broadly identifying the source of authority and the way that the county was set up was sufficient. They didn't have to go into all the details. And again, we're not claiming that they had to go into all the details. The reason this is misleading, we claim, is that the allowed line, the very first line of the ballot language itself, doesn't put somebody on notice that they're creating exceptions to the existing protections. And again, the issue isn't the level of specificity that they would be required to point people back to give them fair notice. But when they're changing these fundamental rules, the ballot language that the voter is going to see when they walk into the voting booth has to give them fair notice of the extent and the nature of the changes that they'll be voting on. And we believe that because it did not say that this was creating exceptions, because it did not say that this actually didn't just change the charter to allow this lease, but created a whole slew of exemptions, that the people were not told about that. They weren't given fair notice. And if they weren't given fair notice, then the election itself is a nullity. The Wadhams case and the other cases that are kind of after the election cases are clear that if the ballot language is defective, then the voters have there's no presumption about the validity of the vote, because this goes to the fundamental issue of whether the voters knew fairly about what they were voting on. And so the vote itself gets no presumption of validity. It can't bless the language after the fact. And if the language is defective, the court is obligated to strike the amendment. The trial court was obligated to do that and did not. This court is obligated to do it, and instead this is de novo review. It's a purely legal matter of interpretation of these documents. There are no factual issues on which the trial court gets deference. Again, when you look at the context of this as a whole, the chief purpose if they did not have to have these exemptions, they wouldn't have needed the amendment, if they didn't want them to do this particular deal. They wanted a deal that was restricted by the charter. And they wanted to get around those provisions. That's fine. The voters have the power to exempt this deal from those other protections that they put in the charter. But they need to be told that that's what they're doing, and they weren't. Because they weren't, the ballot language is defective, and the court should strike the amendment.
Thank you, Mr. Lincoln.